Chapter 63 Aboriginal Law in a Family Law Context 1. Introduction. As a general rule, family and child protection laws that apply to individuals in Ontario also apply to Indigenous people in the same way. However, there are some very important exceptions that must be noted. As a preliminary matter, the practitioner should be aware of the impact of self-governance on Indigenous communities. Some First Nations have enacted their own laws, through inherent jurisdiction, self-government agreements, or by lawmaking authority under the Indian Act, that may displace provincial legislation in Ontario too. Marriage. Canadian courts have upheld customary laws on marriage and adoption even in the face of legislation that might be taken to have abridged such laws. For example, the validity of a marriage under Cree customary law between a non-Indigenous man and a First Nations woman was upheld. As well, in another case, it was held that the customary wife of a man accused of a crime may refuse to testify against the man based upon spousal privilege. It appears that so long as the customary marriage meets the criteria of common law marriages in that the marriage is voluntary, the parties intend the marriage to last for life, and the marriage is not polygamous, it may be recognized as a legal marriage. See Norman K. Zlotkin, Judicial Recognition of Aboriginal Customary Law in Canada, Selected Marriage and Adoption Cases, 1984. 4 CNLR 1. 3. Family property. The discussion of division of property applies only to registered Indians under the Indian Act, and thus does not apply to Inuit, Métis, or non-status Indians. The Family Law Act FLA scheme for equalizing the value of net family property applies to Indigenous people. However, provisions for exclusive possession of the matrimonial home where the home is on reserve lands infringe on federal constitutional jurisdiction, as would any other provision that attempts to deal with ownership or possession of property on reserve lands, such as Ontario's Partition Act. The federal government's exclusive jurisdiction over lands reserved for Indians means that provincial statutes such as the FLA do not apply when it comes to dividing ownership or possession of on-reserve matrimonial real property. However, they would apply to the division of the value of said property. This left courts and legal counsel looking for remedies that did not involve ownership or possession of reserve property. One option has been an order requiring the spouse in possession of the reserve land to pay cash or transfer other non-reserve property to the other spouse's compensation in lieu of a division of reserve property. There are, of course, practical difficulties associated with such a remedy, including arriving at a fair valuation of reserve property. Assets that do not consist of interests in reserve land may be divided pursuant to provincial legislation such as the FLA because they divide value and not the asset itself. In attempts to address the gap, the federal government enacted the Family Homes on Reserves and Matrimonial Interests or Rights Act, FMIRA. Sections 1-11 and 53 came into effect December 16, 2013. These sections recognize the power of First Nations to enact laws regarding the use, occupation, and possession of family homes on reserves upon the breakdown of a conjugal relationship or death of a spouse or common law partner. Sections 12-52 came into force December 16, 2014. These sections contain provisional rules regarding the possession and division of property on reserve on the breakdown of a conjugal relationship. These rules apply to all First Nations unless they have already enacted a law regarding family property or until they enact their own law under the FMIRA. The provisional rules under the FMIRA apply to both spouses and common law partners if at least one of them is a First Nation member or a registered Indian under the Indian Act. It contains provisions for the following: the occupation of the family home, emergency protection orders, exclusive occupation orders, the division of the value of matrimonial interests or rights, the role of the chief and council, First Nation leadership, in proceedings under the FMIRA, and enforcement. Lawyers advising spouses or common law partners who reside on reserve or with real property on a reserve must inquire with the First Nation about whether there are any applicable First Nation laws that will affect family property issues, and if not, they must become familiar with the provisional rules under the FMIRA. It is important to note that these provisional rules create substantially different, and additional, rights for spouses and common law spouses than what is provided for under the FLA. The family law rules apply to proceedings under the FMIRA and for proceedings under First Nation laws under the FMIRA. 4. Support orders. Child support is available under both the Federal Divorce Act and the Ontario FLA. Both acts incorporate the Federal Child Support Guidelines, which calculate the amount of child support that must be paid per child according to the paying parent's income. The recipient parent's income is relevant only when considering the special and extraordinary expenses that must be paid by the paying parent over and above the basic table amount, as well as undue hardship. The major difference in dealing with registered Indians under the Indian Act in relation to child support orders has to do with the application of S19 of the guidelines. This section states as follows. 19. 1. The court may impute such amount of income to a spouse as it considers appropriate in the circumstances, which circumstances include the following. B. The spouse is exempt from paying federal or provincial income tax. This section has been applied to gross up the income of registered Indians earning income, which is exempt from income tax, to determine the amount of support payable. 5. Enforcement of support orders by virtue of S89 of the Indian Act. Registered Indians are exempt from the garnishment or seizure by non-Indians of property located on a reserve. Property includes bank accounts and income located on reserve. In cases where the dispute over support is between two registered Indians, the garnishment of property or income earned by an Indian may be valid. In cases where the spouse attempting to enforce an order is not a registered Indian, the registered Indian may be exempt from garnishment for property located on a reserve, and the creditor spouse may have to look for alternative ways to enforce the support order. 6. Customary adoption. Customary adoption is an integral part of indigenous societies and is commonplace in indigenous communities. Customary adoptions have been recognized by the courts. According to the court in Ritagornak, there are 4 criteria for recognizing a customary adoption. There must be evidence that the custom extended back in time as far as living memory. The custom must be reasonable. The custom must be certain in respect of its nature generally, as well as in respect of the locality where it is alleged to obtain and the person whom it is alleged to affect. The custom must have continued without interruption until the present. Customary adoption practices of an indigenous group, community or people are also recognized in an act respecting First Nations, Inuit and Métis children, youth and families. FNMSIF 7. An act respecting First Nations, Inuit and Métis children, youth and families generally. Child welfare is a matter of provincial jurisdiction under S92, 15, of the Constitution Act, 1867. The federal government also has a role with respect to Indigenous peoples, pursuant to S91, 24. In Ontario, child welfare services are regulated by the province, primarily through the Child, Youth and Family Services Act, CYFSA, which replaced the Child and Family Services Act and came into force in 2018. However, on January 1, 2020, FNMSIF came into force. FNMSIF upholds the right of First Nations, Inuit, and Métis of self-government, affirmed by S35 of the Constitution Act, 1982. FNMSIF includes jurisdiction in relation to child and family services and establishes national principles such as best interests of the child, cultural continuity, and substantive equality to help guide the provision of child and family services in relation to Indigenous children. The principles are intended to guide Indigenous communities, provinces, and territories on the delivery of child and family services, help keep families together, and help reduce the number of Indigenous children in care. FNMSIF is designed for Indigenous communities to exercise partial or full jurisdiction over child and family services at their own pace. Depending on the path chosen by an Indigenous community, the exercise of its jurisdiction could result in its laws prevailing over federal and provincial laws, including the CYFSA. FNMSIF applies to child and family services provided by any agency, whether directly by the province or by First Nations, Inuit, or Métis delegated agencies. As of January 1, 2020, note the following. Indigenous groups who develop their own legislation will have 2 options to exercise jurisdiction under FNMSIF. 1. Send a notice to the Minister of Indigenous Services and relevant provincial or territorial governments of their intent to exercise their jurisdiction. Or 2. Send a request to enter into a tripartite coordination agreement with Indigenous Services Canada ISC, and relevant provincial or territorial governments. Every service provider delivering child and family services to Indigenous children and families will need to follow the minimum standards found in FNMSIF. Existing agencies will continue to provide services to Indigenous children. Agreements related to existing delegated agencies will remain valid unless the parties decide otherwise. If Indigenous groups are currently at discussion tables to conclude agreements, they can still exercise jurisdiction under the framework of FNMSIF. Indigenous groups that choose to exercise their jurisdiction could continue working with delegated agencies or could create their own delivery service models. FNMSIF provides that agreements such as treaties and self-government agreements in relation to child and family services between indigenous groups and federal, provincial, or territorial governments that predate the coming into force of FNMSIF prevail in case of conflict. The ISC website will contain information related to notices of intent, coordination agreements, and indigenous laws as they are made available. It is important for practitioners involved in family law and related matters where indigenous children may be involved to consult the ISC website for an understanding of the legal landscape in their particular circumstances. 8. The Child, Youth and Family Services Act Paragraph 1, 2, 6 of the CYFSA recognizes the following principle. First Nations, Inuit and Métis people should be entitled to provide, wherever possible, their own child and family services, and all services to First Nations, Inuit and Métis children and young persons and their families should be provided in a manner that recognizes their cultures, heritages, traditions, connection to their communities, and the concept of the extended family. To that purpose, the CYFSA has many provisions unique to Indigenous children and youth. The most obvious change in respect of the distinct treatment of Indigenous children is that the repealed CFSA referred throughout to Indian and Native children and gave certain rights of notice and participation to a representative chosen by the child's band or Native community. The new CYFSA refers to First Nations, Inuit and Métis children and young persons and gives extensive rights of notice and participation to a representative chosen by each of the child's or young person's bands and First Nations, Inuit, or Métis communities. References in the CYFSA to a child's or young person's bands and First Nations, Inuit, or Métis communities include any band of which the child or young person is a member, any band with which the child or young person identifies, and any First Nations, Inuit, or Métis community that is listed in a regulation and of which the child or young person is a member or with which the child or young person identifies. This acknowledges that a child or young person may have a connection with multiple bands and/or communities. Courts continue to have a positive obligation under S90, 2b, of the CYFSA to determine whether a child is a First Nations, Inuk, or Métis child and, if so, the child's bands and First Nations, Inuit, or Métis community. Regulations under the CYFSA set out rules for such determination. In cases involving the custody, adoption, apprehension, and placement of children, Ontario courts must address the best interests of the child. In determining the best interests of a First Nations, Inuk, or Métis child, the CYFSA requires that courts also take into consideration the importance, in recognition of the uniqueness of First Nations, Inuit and Métis cultures, heritages and traditions, of preserving the child's cultural identity and connection to community. The definition of extended family is expanded in relation to First Nation, Inuit, and Métis children to be more inclusive of the broader First Nation, Inuit, and Métis communities. In cases of child apprehension, placement, custody, and access, the CYFSA makes a representative of each of the child's bands, First Nation, Inuit, or Métis communities an automatic party to the proceedings. Where the court orders that a First Nation, Inuk, or Métis child is in need of protection, S101, 5, requires the child be placed with a member of the child's extended family if possible or with another First Nation, Inuit, or Métis family, as the case may be, unless there is a substantial reason for placing the child elsewhere. As well, for a First Nations, Inuk, or Métis child, a Children's Aid Society CAS has a positive obligation to make all reasonable efforts to pursue a plan for customary care, as defined in the CYFSA, if the child is in need of protection, cannot remain in or be returned to the care and custody of the person who had charge of the child immediately before intervention under the CYFSA or, where there is an order for the child's custody that is enforceable in Ontario, of the person entitled to custody under the order, and is a member of or identifies with a band, or is a member of or identifies with the First Nations, Inuit, or Métis community. The CYFSA contains extensive consultation requirements. For example, S73 requires a CAS, person, or entity that proposes to provide a prescribed service to a First Nations, Inuk, or Métis child or young person, or to exercise a prescribed power under the CYFSA in relation to such a child or young person, to consult with the representative chosen by each of the child's or young person's bands and First Nations, Inuit, or Métis communities in accordance with the CYFSA regulations. Sections 69 and 70 of Part IV of the CYFSA permit bands and First Nations, Inuit, and Métis communities to enter into agreements with the Minister of Children and Youth Services for the provision of services under the CYFSA and for bands and communities to designate a body as a First Nations, Inuit, or Métis Child and Family Service Authority. The Minister under S70. 2. C. May designate the Child and Family Service Authority as a CAS under the CYFSA, with its consent. There are presently 59 CASs across Ontario, including 11 that are Indigenous. An important inclusion into the CYFSA is a recognition of Jordan's principle, namely that interjurisdictional or intrajurisdictional disputes primarily associated with responsibility for payment should not prevent the timely provision of services. Practitioners involved in family law matters where there is any possibility that the child is Indigenous are faced with many different obligations and procedures under the CYFSA, making a thorough review of the provisions mandatory. Chapter 64 The Change of Name Act. The Change of Name Act CNA establishes the name by which a person is entitled to be recognized for purposes of Ontario law. It also outlines the circumstances in which a person may change that name and the steps they must take. This chapter reviews the provisions of the CNA in general terms. For complete details of the statutory provisions, reference must be made to the Statute 1. General provisions subject to the exceptions listed in the statute. A person whose birth is registered in Ontario is entitled to be recognized by the name appearing on their birth certificate. If they have changed their name pursuant to the CNA or its predecessor statute, they are entitled to be recognized by the name on their change of name certificate S2. 1. Any person at least 16 years of age who has been ordinarily resident in Ontario for at least 1 year immediately preceding the application may apply to the Registrar General to change the person's forename, surname, or both or the person's single name if the person has a single name. S4. 1. A person may not change the person's name so as to have only a forename or only a surname. S2. 3. However, despite S2. 3. A person's name may be changed to a single name that is determined in accordance with the person's traditional culture if the prescribed evidence is provided to the Registrar General and the Registrar General approves the single name. S2. 4. The form of application to be submitted is specified in General RRO 1990, Reg 68, made under the CNA. The application must be accompanied by the following: a statutory declaration containing all the information outlined in S6. 2. Of the CNA any required acknowledgement of notice. Form 6. S6. 7. The consent of every person who has lawful custody of the applicant. Form 7 or a copy of the court order dispensing with such consent. This is applicable only if the applicant is over 16 but under 18 years of age. SS4. 3. 4. A statement of a person who knows the applicant confirming that the residency requirement has been met. Form 8. The statement must be by either a member of a prescribed class, listed in Form 8, who has known the applicant for at least 1 year or by any person who has known the applicant for at least 5 years. SS6. 3. 5. All birth certificates and change of name certificates that are in the applicant's possession. S6. 8. A request for a name change to a single name, if applicable. General. S4. 3. A police records check, if applicable. SS6. 9. 10. The prescribed fee. General. S5. Survivors of residential schools and their families can apply for a change of name in order to reclaim a traditional Indigenous name without paying a fee until January 2022. Upon receipt of the application, the Registrar General registers the change of name and issues a change of name certificate and, if the person was born in Ontario, a new birth certificate. CNA. S7. 1. If the Registrar General believes that an applicant is seeking a change of name for an improper purpose, the Registrar General may refuse the application. If an application is refused, the applicant may, on notice to the Registrar General, apply to the Ontario Court of Justice for an order granting the application. SS7. 2. 4. Unless the Attorney General or a person authorized by the Attorney General certifies that a change of name is intended to prevent significant harm to the person whose name is being changed. Upon the registration of a change of name, notice of the change of name is published in the Ontario Gazette. The change of name is entered in the Change of Name Index maintained under the Vital Statistics Act. and in the event that the Registrar General was advised that the Ministry of Community Safety and Correctional Services has information about the person that would be included in a police records check, notice of the change of name is provided to that ministry. SS 8. 1. B. 1. If the application for a change of name discloses an unsatisfied execution against the applicant, that the applicant is an undischarged bankrupt, that there is a registration in the applicant's name under the Personal Property Security Act, or that a pending court proceeding exists against the applicant, notice of the change of name will be given to the sheriff of the jurisdiction where the unsatisfied execution exists, the Registrar of Personal Property Security, the Registrar in bankruptcy, or the clerk or registrar of the court, whoever is appropriate. S. 8. 1. C. A person may request that notice of the change of name not be published because the person to whose name the application relates is, at the time of the application, a transgendered individual or a First Nations, Inuit, or Métis individual. General. S. 6. A person who believes that a change of name was obtained by fraud or misrepresentation or for an improper purpose may apply to the Ontario Court of Justice for an order revoking the change of name CNA. SS 10. 1. If satisfied that the change of name was obtained by fraud or misrepresentation or for an improper purpose, the court may revoke it in whole or in part. Ontario Court of Justice decisions can be appealed to the Superior Court of Justice by the person to whom the name change relates, the applicant, or the Registrar General. S. 11. The CNA identifies offences under the Act related to obtaining or using a name obtained by fraud, using a name that was refused or revoked, failing to surrender a name change certificate upon revocation, or using a birth certificate or name change certificate showing a former name. S. 12. 2. Marriage and cohabitation. The CNA provides an abbreviated procedure for people who wish to change their name as a result of marriage or the dissolution of their marriage. The abbreviated procedure is available to spouses at any time during the marriage but only if a spouse is changing the spouse's name to the surname that the other spouse had immediately before the marriage. A surname consisting of the surnames that both spouses had immediately before their marriage, hyphenated or combined, or the surname that the spouse had immediately before the marriage. S. 3. 1. If spouses wish to change their surname to something else or to change a forename, they must apply using the lengthier procedure described in the previous section, at any time after the dissolution of a marriage by divorce, annulment, or the death of the other spouse. Former spouses may use the abbreviated procedure to elect to resume the surname they had immediately before the marriage. S. 3. 2. To use the abbreviated procedure during a marriage, a spouse must complete and submit Form 1 General. S. 1. 1. To use the abbreviated procedure following the dissolution of a marriage, a spouse must complete and submit Form 2 General. S. 1. 2. In both cases, the form must be accompanied by a marriage certificate, all birth certificates and change of name certificates in the applicant's possession, and if applicable, a police records check. An application following the dissolution of a marriage also requires proof that the marriage has been dissolved, a judgment of divorce, divorce order, nullity, or death certificate. General. S. 1. 3. It is not necessary to give notice of either of these applications to the other spouse. CNA. S. 3. 8. Upon receipt of the fee, if applicable, and documents, the Registrar General issues a change of name certificate and, if the person was born in Ontario, a new birth certificate. While the new birth certificate will contain only the newly adopted name, the original certificate on file with the Registrar General will indicate the birth name and each successive change of name. It has been found that the predecessor statute to the CNA did not override the common law, so the CNA is probably voluntary rather than mandatory. If that is the case, there is nothing to prevent a spouse from assuming the other spouse's name upon marriage without any application under the CNA. If this is done, the only difference would be that the birth certificate would continue to bear the birth name, not the newly assumed name. After marriage, an individual can assume their spouse's name on their health card, driver's license, Ontario photo card, and enhanced driver's license by attending a Service Ontario Centre with the individual's marriage certificate and required identification. The abbreviated procedures available to married spouses are also available to people living together in a conjugal relationship outside of marriage, including same-sex couples. If the couple files a joint declaration in Form 3 acknowledging that they are living together in a conjugal relationship outside marriage. CNA. S. 3. 6. General. S. 1. 6. Either party may then avail himself or herself, without notice to the other person, of the name change procedure available to married spouses. Once a party in a conjugal relationship outside of marriage has changed the party's name, the previous surname can only be resumed without the necessity of a general name change if one of the parties files a declaration in Form 4 stating that the relationship has ended. CNA, S3, 7, General, S1, 7, 3. Children. If the residency requirements of the CNA are met, a person with lawful custody of a child may apply to the Registrar General to change the child's forename, surname, or both, unless a court order or separation agreement prohibits the change. S5, 1. Where a person is declared under S10, 11, or 13 of the Children's Law Reform Act to be a parent of a child and obtains an order under that act changing the child's surname. An application for a child's change of name also requires the consent of that person. CNA, S5, 2.1. The application to change the name of a child requires, among other things, the written consent of any person with lawful custody of the child or any person whose consent is necessary in accordance with a court order or separation agreement, as well as the child's consent if the child is over the age of 12 and is capable of consenting. If the required consent cannot be obtained or is refused, the person seeking to change the child's name may apply to the court for an order dispensing with that consent. S5, 4. Appeals from decisions dispensing with consents under either S4, 4 or 5, 4, may be made to the Superior Court of Justice by the person whose consent was dispensed with. S11, 1. Notice of the application must be given to every person who is lawfully entitled to access to the child, but the application does not require the consent of a non-custodial parent unless this consent is required by court order or separation agreement. S5, 6. This provision is significant for family law practitioners. They must warn every parent consulting them that if the parent does not have custody of the child's name could be changed without the parent's consent. If the issue of custody is litigated, the lawyer representing the access parent should request an order that the custodial parent may not change the child's name without the consent of the access parent. If custody is not litigated, lawyers acting on behalf of access parents should ensure that a clause prohibiting a change of name is inserted into any separation agreement. In ZHO v. Chen, Nelson J. held that the fact that a separation agreement prohibits a name change is only one element in the court's decision as to whether a child's name may be changed. The court has jurisdiction to override such a prohibition if it is not in the child's best interests. S5, 5. Only July 1, 2020, Bill C-78 will come into force. The updated Divorce Act will replace the language of custody and access with decision-making ability and parenting time. However, at this time, the CNA continues to use the language of custody and access. Any court order or separation agreement that uses the language of parenting time and decision-making ability should also clearly address the issue of changing a child's name and set out who is entitled to apply for a name change and whose consent is required for a name change. It remains to be seen whether the province will amend the CNA with respect to the language of custody and access. Neither the CNA nor the case law makes clear how an access parent should proceed if the access parent receives notice of an application to change a child's name and wishes to object to it. Since the access parent's consent is not required to change the child's name, the Registrar General will proceed with the application unless a court order is served upon them. The first step a lawyer should take when retained by an access parent with this problem is to contact the Office of the Registrar General, advise them of the access parent's objection, and ask for a grace period to permit the access parent to obtain a court order. The lawyer should then advise the custodial parent of the access parent's intention to commence court proceedings over this issue. If the custodial parent insists on proceeding with the application for the name change, the lawyer must immediately commence a proceeding seeking to vary the existing custody order or vary the terms of the separation agreement between the parties. To prohibit the name change, it is up to the parent opposing the name change to demonstrate that a name change is not in the child's best interests. In considering the best interest of the child, courts will consider a variety of factors as set out by Sher J. and Hermanson v. Kyrie. It is important that the application seek an order varying the existing custody order, not just an order prohibiting the name change, since case law has established that name change is an incident of custody. In Felix v. Frat Petro, Platana J. dismissed an application for an injunction restraining a name change that did not seek a variation of the existing custody order. If there is an existing custody order, any application to vary it must be brought in a court with jurisdiction to do so. If the original order was made in the Superior Court of Justice, the Ontario Court of Justice does not have jurisdiction to vary it. It is important to note that the Ontario Court of Justice does not have the jurisdiction to make an order changing a child's name, and there is no statutory authority that can compel the Registrar General of Ontario to change a child's name under the Vital Statistics Act. However, the Superior Court of Justice can make an order under their parens patriae jurisdiction to order the Registrar General to amend the birth registration of the child Hermanson v. Kyrie, if an access parent seeks to set aside a change of name that has already been registered. The only remedy under the CNA appears to be an application to revoke the change of name on the basis that the change was obtained by fraud or misrepresentation or for an improper purpose. S10. 1. If fraud, misrepresentation, or improper purpose cannot be proven, there is no statutory remedy available. Van Buskirk v. Osborne.